Hello. I've got a little puppy dog saying hello too. This is Concertina's dog, Hugo, and he's come to visit.
Oh, how cute.
He's my office dog today. How are you?
Oh my goodness. Hugo is so welcome. I'm really well. How are
Yeah,
you?
I'm good. A little bit stressed. I'm good. About to step on a plane to Chicago. So, yes, and without Concertina, life is pretty interesting.
What did you just say? You're about to go to Chicago.
Yeah, so I'm speaking at the IACP conference on collaborative practice for wills and estates over there.
Oh my goodness. Well, that sounds fantastic. And if you learn anything, we'd love to have you feed that back to the group as well.
Absolutely, happy to.
Sure. And I should say not what you learn over there.
I will. I'm sure I absolutely will. Absolutely. I'm there to do that.
Well, I'm super grateful for you squeezing us in to be able to share about your statutory will application, because I saw you posted about it weeks ago.
Yeah.
And as soon as I saw that, I was like, oh my goodness, we need to hear the actual story from you, because it sounds amazing.
Yeah. You mean the social story? As in like the fact that we were drinking lots and lots of champagne when we got the call, that one, or the actual legal story?
Well, yeah. What do you want to talk us through it? I just knocked my water bottle over,
Well,
I'll
talk about the interesting social side of things first, and then I'll tell you the law side of things. Yeah. So we had a client come in for a second opinion actually a few weeks before that, where her situation was that she was a goddaughter of the lady for whom the statutory will. So PA application, so couldn't wait until the lady had passed. She had kind of sadly been told by another lawyer before us, and in fact really scared, into being told that she shouldn't make the application. She would look like a money grubbing person. She would potentially go to jail. I mean, like couldn't even tell you the advice that she had. So she came into us quite timid and quite scared about the prospect of her application. But she had very strong evidence of her care of the lady. There was quite a substantial change in the lady's circumstances since the first will had been made, as in, so she was a goddaughter to this lady, but she was very much, she had not married herself, never had her own children. And so really she saw our client as her daughter. And even though she was quite independent for most of her life, she had made her will back when she was independent. And so she had left bulk of her estate to about 6 different charities. And she was really a very generous person. So you could sort of, and when she moved into her nursing home, she kind of shacked up with a man that wasn't really meant to be a boyfriend, but he kind of was, and he looked after her for a while. And then when he passed away, then she really became quite dependent on Our Lady for everything. And Our Lady did everything without any expectation. She was her enduring power of attorney, and she looked after all of her affairs. But over and over the years, she had expressed to several people for several good reasons. So she had a nurse that came in and looked after her, funded privately nurse who would be her companion and look after her. And she expressed, so she had broken her arm, so she was going to go into hospital, and she had told this nurse, who was a completely independent person, that it was her wish that her estate would go to Our Lady, and that she would then look after the distribution of that, to a couple of charities here and there. Like, it wasn't really anything huge in terms of, she just said she wanted to give the charities less than what she'd given. So she herself believed that her will said that was what was going to happen. In fact, the will really only appointed our client as executor, and only then one of 3 executors. There was a solicitor from a prior the firm, plus an old accountant who had been her accountant before that. And she said it over again, and she just kept, and she even kept, when she started to get she got dementia, she used to go down to the reception and over and again say, I need to make sure that my will says that, you know, Mandy gets it all. You know, she was just, but by that stage, really, she had been assessed as not having testamentary capacity. She made multiple attempts trying to call who she believed were her solicitors, and that was a legitimate, again, reason for not knowing her solicitors, because that changed because of a firm closure. So she had had that solicitor's firm for a number of years, and then they closed. And so then we had all that sort of evidence, and we had lots of little scrappy old lady writing hand notes of all this stuff, but of how she wanted her will to go. But really, we had nothing else other than that kind of thing. So our trouble really was that we had commenced by notifying the charities that were in the first will. We were met with significant resistance from the solicitors who had drafted that will. They were unwilling to hand over their file or provide any evidence in relation to the lady's, you know, making that will or her wishes, or why indeed our lady wasn't named as a sort of substantial beneficiary in the prior will. We just had resistance, and we were just being met with that. I suspect that the firm thought that they were going to be on the hook for something down the track. Nevertheless, we then wrote to all of the charities that we had that we could track and trace, because of course some of the names had changed, and we wrote to them and gave them a draft will. Now, our client was just one of your typical I don't deserve anything type of people. She was not in this for the money. We were telling her, well, I mean, she was, because she knew that her lady's, you know, her godmother's wishes were that her family would receive the money. But she wasn't in it to get it all for herself personally. So we were telling her, really, the evidence was showing that she should get a significant portion of the estate, if not all of it. But we drafted the will on the basis, the draft will, on the basis that she only take 50%. So the charities were still taking the remaining 50%, and it was about a $3 million estate. So it wasn't huge, but it wasn't small either. So the 6 charities would then share the balance of the 50%. And we sent them out what we had then as the best evidence from our very first client meeting, which was a statutory declaration prepared by this one nurse who had seen her over and over, setting out one extract of diaries that she had kept with her notes of what she understood this lady's wishes to be. And the medical evidence that we had at the time in terms of when she lost capacity, or indeed that she had lost capacity, and therefore the statutory will was required to be made. Now, that probably was our saving grace, because what ended up happening to us was that we had set the matter down for a hearing date, again, trying to pick our judges a little bit, you know, hoping that Our Lady would last. And then, and we had taken the additional extra step of appointing a litigation guardian, an independent person, Craig Spink, to be, with the intention that he would go and see the lady, despite the fact that we knew she didn't have capacity to make a new will, but at the least to have an independent discussion with her around what her wishes were, because we were quite confident that she would tell him that she wished her estate to benefit Mandy. And what he was all lined up to do that, and then the nursing home got hit with gastro, so they went into lockdown. And then what happened was that Our Lady the lady for whom we were making the application, got severely dehydrated. She was already in her 90s and then slipped into a coma. So we were out to lunch. We had been out to lunch, and at about 5 p.m., I think we were into our fourth bottle of champagne. It was amongst 5 of us, so it wasn't that bad, but it was still not great. We got the phone call from our client that this lady was critical, and she was being, she was unlikely to make it through a couple more hours, or perhaps a day at best. So we basically had to tell our client, get her into an ambulance, get her to a hospital, get her on a drip, and assess whether or not she can even be kept on life support, because you don't actually know whether they can be at that point. And she was like, what, serious? Like, she was just in shock. Our lady was like, what do you mean? What do we need to? And we're like, we have to go to court, and we have to go now. And she's like, but court? And yeah, so we're like, we have to open the court and we have to go, and we have to go now. So that is what we did. I rang Kate Brewer because I knew she had done this before, and I'm like, how does one open the court and how does one sober up really quickly? But really, really, that's what we had to do. We picked up everything. I literally put my glass down as soon as I saw the client was calling in, and we just had to do that. So we've written a Proctor article, Darlene Skinner and I, on the actual process of opening the court. So I won't, unless you want me to, won't necessarily go into all the ifs, buts and maybes there, unless you want me to. Tara, what do you want me to do? Do you want me to talk about that?
No, that's fine. I think I have that Proctor sitting on my desk, so I might scan that in and put it in the group,
absolutely.
so we don't have to.
Yeah. We can. So that might help. That's just the actual aspects of what you do to open the court after hours if you have to. And then we were on in the application. And as I mentioned before, I think really taking the additional step of writing immediately to all of the charities with the proposed draft will and our best evidence, even though we were then collecting a lot more evidence after that, was a saving grace, because what ultimately ended up happening was we had solicitors we could not get in touch with. So we had a solicitor, thankfully we had a solicitor who had before then been able to garner, I think he was acting for 5 of the 6 charities. So we already knew that. We already knew that they were opposing the application, so we could communicate that to the court to say the charities were opposing the application. We knew who their counsel was, but he's a very early riser. It was Robert Whiteford. He's a very early riser. And so by the time we had the patient assessed, were told that she couldn't be kept on life support, that we were, hours, potentially away from her death at the time, we basically had to go whether we had them there or not. And we were trying to raise him on the mobile phone. We were just doing everything we possibly could to get in touch with both of those parties, but could not raise anybody. So we had to go.
What time of the evening was this?
Yeah, so by the time we had the lady assessed, it was probably about 9 p.m. So by that stage, we were well and truly sober, just FYI. It's amazing how quickly you sober up when you got to. So we basically made the dash back to the office to complete all of the material that we had already done significant work on. And thank goodness, Concertina had already interviewed the nurse, and we had a significant affidavit, because not only did she have the one little statutory declaration that she'd prepared, she had every day she took notes of when she met this lady and what she said. So we had multiple instances of her, both before and after she lost capacity, saying her intentions. So we had, pretty strong evidence around her intentions. We didn't have the opportunity. Oh, actually, I think we had served by email that afternoon that affidavit, but our own client's affidavit wasn't sworn or ready to be served. So yeah, we just didn't have the time. We just couldn't get across it all. So we just finished everything off that we needed to do. Our client met us in at Chambers. Poor Darlene Skenner had to drive back from the Gold Coast because she was already on her way down there. And we got it all before the court. And Rebecca Treston was briefed for Craig Spink. And so he was as I mentioned before, he was the litigation guardian. Now, Rebecca and Darlene Skenner spoke because we knew that we couldn't get a hold of counsel or any representation for the charities. And so Rebecca again suggested, and I think this again was another reason why we were successful and why the application wasn't appealed, because that was the other reason why I was a bit like nervous saying, oh, can we just leave it a little bit later until those 28 days have passed before we talk about this? Yeah, so she basically acted as contradictor, and which means that she put before the court whilst saying we don't oppose, they didn't oppose the application. They couldn't really add anything because Craig hadn't had the chance to go and speak to the lady in question anyway. But she could put before Her Honour all of any potential argument that might have been raised on behalf of the charities, such as, the question wasn't really answered as to why Our Lady hadn't featured in the prior will as a, major beneficiary. And, and similarly, we had also done, Concertina had also put together some really good evidence in terms of all of the bank accounts of the lady, because Our Lady was her attorney, of the history of the giving of the lady. So it was quite clear she was a generous lady, and the anecdote really was that she loved to have a chat on the phone. So when those pesky charity people ring, or she would just keep them on the phone and chit chat to them, and that was her social life. So, and at the end she'd give them $10, or so she wasn't making the bequests during her lifetime weren't huge. So each of these charities who stood to gain a sixth of $3 million probably only received during her lifetime a couple of $1,000 over years of giving. So, that was another thing. And I think really the other evidence that was being put before the court was obviously all of the tests, all of the stuff that we need to do in terms of would this have been a will that she would have made. And again, the evidence of her in consistently ringing the solicitor, consistently saying to people that she wanted to make sure that her will, left the money to Mandy, etc., was what got us across the line there. And Her Honour really sort of said, well, she understood that the charities opposed, but she made the comment that, had they been given the complete evidence that we had then been able to put together for the court application, she said they might have taken a different view. So their first reaction was to oppose, but, had they been given the full evidence, they might have taken a different view. So I think really, again, we just did what we had to do, because it requires, I think the section requires you to have taken adequate steps to inform all of the parties, interested parties of the application. So even though they weren't there present representing the charities, we had taken those steps of advising them of the application, giving them the proposed draft will, and there was no change apart from, I think, one of the charities had been misnamed. We even had the situation, as I said to you before, we had one solicitor acting for then 5 of 6 charities. So we didn't even have certainty as to the service of the 6th charity. But it was clear enough from the evidence that we had before the court that 6th charity had been in touch with that solicitor, and he had said he was yet to receive instructions to act for them. So they obviously had notice of the application, etc., etc. So yeah, and we had to go out and check that Our Lady was still alive before the order was made, and then the registrar sealed the will, and we got it, and we finished at about 1:30 a.m. And our client still, she had stepped outside of the court to check, to get in touch with the doctors. And she was even saying to Concertina, just tell the court I'll have $50,000, just as long as my you know, all the stuff that I've paid for or even my time, that'd be fine. And we walked out and she said, you know, when we told her we got her 50%. And I think that was another thing. We weren't greedy. We did. And even the judge said, you know, we could have potentially, she might have made the will in a more generous fashion to our client, but on the balance of probability, she agreed that the will would probably be one that she would have made in all of the circumstances, having regard to her generosity over the years to charities generally, whether or not it was these particular ones. So, yeah, so we got there, and it hasn't been appealed. Woo! So, yeah, we're now in the process of actually doing the probate for that will, so we get it all sorted. So she'll get 1.5 mil out of it all.
Wow, what a story.
Yeah.
And well done to you and Concertina. That is amazing work at the last hour.
Yes, it was pretty intense.
Do you mind if I ask, how soon after the application did the testator pass away?
Oh, yes, that was just dandy. So because she was hydrated, she hung around for like another 4 days, and it was awful because we just felt so bad because we'd woken everybody up. And as Rebecca said, got me out of my pajamas. Yeah, and the judge had, yeah, so she lasted until I think it was the Thursday, which was awful because we felt awful because, you know, you don't want to keep a person alive, you know, unnecessarily, but at least she was hydrated. I don't know.
So the application was made on a Friday evening.
Yes.
Yeah. So I mean, you just don't know because it would have been closed for the whole weekend.
Oh no, absolutely. And the evidence we had from from the emergency hospital was that it was hours, at most a day. They did not expect her to last more than a day. So we completely expected her. I mean, and we basically had to step outside the courtroom to ensure that she had indeed survived, because we started at about 11 p.m. and I don't think her Honour was ready to make the order until about 1 a.m. So there was still a number of hours there. And again, at Rebecca Treston's suggestion, she even said, look, I think you should make the order for the will, if that's the way you're minded, and then give your reasons, so that the will could be off getting done in case she did pass away.
Yes.
So, I mean, we were all expecting that she may not have even made it, because we had to still satisfy the court that she was alive at the time the will was being ordered to be made. So, I mean, it was touch and go at the time. It was just awful. Yeah. So Thursday, a week, and we're all just going, can you just die already, please, Gwen, die. So, you can go. I'm going, can't you hear the angels calling me now? Just go, please. It was so embarrassing.
Okay. I mean, it's an amazing story. So, are you okay for us to ask you some questions now, or was there more you wanted to add?
No, go right ahead.
So I have a few questions.
Yep.
I'll also field any. So I guess. Okay, so one of my questions I had before this was, who's your client, and is there a conflict of interest? And so you sorted that by appointing an independent litigation guardian for the testator.
Actually technically need to do that, because she would have been an applicant. She was the person's attorney. So she would have been an applicant that would have been an appropriate applicant. But because she was the one who was going to take the benefit, really we just thought that was an appropriate step to take, because we just didn't want it to look like she was just going in for herself, really. Yeah, and that's the way we got around it. And Craig Spink has had significant experience in statutory will matters. So when I rang him collegially, just to sound out whether he thought that was necessary and whether he'd be willing to take on that role, he and even whether or not I was, because I was second guessing myself, because the referral for the second opinion, well, not referral from the second opinion, but the first solicitor was an accredited specialist as well. And so you do second guess yourself a little. My gut was immediately saying you've got a claim and you need to make it immediately. And so anyway, but so Craig really thought that the application ought to be made and agreed that it had that additional element of maybe let's get some independence. And so he took on the role for that on that basis. Yeah.
Yeah. And so who pays for the cost of the application? Is it the applicant?
Yeah. So we, yes. The answer to that is yes. I mean, in terms of the practical aspects of if I'm going to court at 11 p.m, I would like money in my trust account, please. Thank you. So, you know, we did. I didn't really. I had 2 weeks before that asked for the money in trust. Let me be clear about that. I wasn't like, well, you know, I don't get out of bed for less than 10,000. No, it wasn't like that. But but look, she did put funds into trust. That's just my policy in terms of that. But ultimately, the court ordered that all of the costs of all of the parties were to be paid out of the estate, as in the lady's estate. So, and that's ultimately what happened, including the costs of the charities who weren't represented. Even though they weren't there, because I think that was appropriate because they still had incurred cost in assessing, you know, the application, deciding to oppose it, and then of course they would have had the additional costs of deciding whether or not they were going to appeal. So yeah, that was the thing. And at the end of the day, in this instance, the estate was, you know, significant enough to cover all of those costs. Yep.
And I mean, going back to your comment before about, you know, this, you had been given the second, or you were giving the second opinion on the likelihood of a successful application. To me, it seems to just come down to the evidence that you can obtain in terms of evaluating that. And I wonder if, as a lesson for, you know, some of the lawyers who are watching and for myself, I wonder if it, you know, a lot of it comes down to, you know, our interview skills in terms of ascertaining what evidence is there around, and, you know, because it seems like you really went to quite great lengths. And if you hadn't had found the nurse or picked up on, you know, all of the information that she had, it could have gone a totally different way.
Oh, look, absolutely. And I mean, obviously the retainer with the first solicitor had already been terminated, and he had made an assessment in terms of, you know, there was the relationship issue for a start. You know, this lady was, you know, treating her as though she were a daughter. So there was a lot of evidence around that. And the evidence in relation, because as I said, these notes were really little old lady handwriting in diaries. You know, some of them were dated, some of them weren't. It was, you know, that they were scrappy. They, you know, and she was quite obviously she was writing down her name and her, you know, her address and her, you know, she kept questioning why someone wasn't coming to pick her up from the nursing. You know, it's all of the stuff that you see in the, you know, these were her personal notes. And some of them, because they were probably quite scrappy on pieces of paper, you know, they might have been discounted for that reason by the solicitor. I'm not sure. They were undated. We didn't exactly have them in order. But I think the nurse's evidence was the compelling evidence. And there he had only been, and I don't know, in fairness, he'd only been given this small statutory declaration. The other evidence that might have been available was that there was this evidence. She used to live in a unit where she was next door to a lady who was her neighbour. And he had attempted, I think, to try and get evidence from that lady. But I don't know whether it was because she herself started to lose capacity or whether she was simply unwilling to be involved in providing any kind of affidavit evidence. So that kind of was, you know, something that he couldn't get evidence for. And I think there were just other attempts at other evidence, and he just sort of said, look, I think he also had this idea that the best Our Lady would do was to receive an equal portion to the charities. So he was talking about a 1/7 share to Our Lady out of the estate, and then he was analysing it on the basis of cost, saying, you know, if it's 1/7 and it's only 200,000, you could spend 100,000 in costs and you're at risk of costs. So I think that was really what his analysis was, but I with respect, think that's incorrect. I think if you've got evidence that says that she wanted Mandy to take all, you know, or bulk, that's really what's at stake. And I remember passing a little note to Concertina at the time when Her Honour was making the order, saying, you know, Mr. X has just dodged a massive, you know, bullet, because if she was minded to make the order and Our Lady had passed away, we probably would have been in a professional negligence lawsuit situation, because I don't think, because he had known of the intention, or he'd been asked to look at the application for a number of years. So it was sort of 2 years. Yeah.
Oh my gosh.
So so ours was really this, and our client, when she came to see us, I think it was like the last 5 minutes of the interview when we left, I said, now look, you know, how is Our Lady, like, in terms of, you know, her health? Is she going to be right? Like, can we get, because she was, remember, as I said to you, my lady was my client, for whom the will was made, not the will was made, but who was the applicant. She was really timid and she didn't really want to do it, you know, and she was quite afraid that she was going to lose her house going ahead with this application and having all these costs, risks, etc., that she had been told. And I again don't agree that there really is, if you are a person who, you know, if you're making the application for proper reason, then the risk of costs is, you know, mitigated, because it's only in the circumstance where a judge says, oh yeah, no, you shouldn't have been making this application, where you're at costs risk, right? In the most case, the courts will award the costs out of the estate. So yeah, so she was really apprehensive about doing the application in the first place. So in that, when she said, oh, every time the nursing home rings me, I think they might be ringing me to tell me that Gwen's dead. I'm like, okay then, so we really have to move really fast now. And that was Concertina's work, because I had another matter where I had like a 5-volume brief that I had to get across. So Concertina was spending a lot of time with our client on the phone, as you were saying, client interview stuff, yeah? Because we really had, not that we had to convince her to make the application, but we had to undo all of the stuff that she had been told by the prior lawyer in terms of all of the fear about making the application. And to be fair, it was probably her hesitation. And I had said to her, look, if we had time, this is how we would do it. We would write to the charities first and we would see if they would consent to the application. But I had even said to her, I don't think we've got the time. We've really just going to have to file the application and serve. And she had said, oh, could we just try the other way first, you know? So thank goodness we did, because as I said, that was the saving grace. So I now say to people, the minute you get it, whatever best evidence you've got, if you have a concern that the person is about to die, just get it across to the other side. It doesn't have to be perfect. Yeah. Really important.
I think that's a great tip for any of the lawyers in the group who, you know, could be involved in a matter like this. I've got one more question, and I haven't seen any questions coming through, which I hope
it means I've explained.
I hope means well, I'm just hoping it's not a glitch, but I think it's because you've done an excellent job explaining it. So, and this is just a hypothetical, and it may be that you haven't done enough to sort of comment, but say the applicant was eligible to bring a family provision application.
Yes.
And so you were sort of sitting here presenting with the options, would you still go with a statutory will application versus a family provision application, or do you think it's better to just wait and bring a family provision application?
Oh, that's a really good question.
Because
it's a really good question.
Because I guess the tests are different, right?
Yes. Yeah, the tests are absolutely different.
Adequate provision versus
someone's intention. Yeah. And I mean, and there was the other more recent case that Craig Spink was involved in. I was involved in on a side. I was acting for grandchildren in that larger estate that went on appeal, where I think Kate Brewer was
the Bundaberg one.
Yeah. So Kate Brewer was acting for the UK daughter. Yeah. And she did in the first instance, she succeeded to argue that the FPA should be something that should be considered at the statutory will application stage, but on appeal, was basically that the court said no, it's not the place. Well, at least in Queensland, it's not the place to be bringing an FPA style application at the statutory will stage. So I think really it comes down to the distinction between the test that you've got to get across in the statutory will is one, whether or not the evidence is such that the testator would have made that will. And so usually the circumstances that I would see it pop up on is really this kind of thing where you've had a will that was made a long time ago, and that then there's some other evidence, whether it, that like ours was, where, she was clearly intending to benefit someone quite different to what was in the will. And in that case, and in our case, we didn't have the ability, because she was just a goddaughter, she wasn't a blood relative, she had no right to make any claim on the estate after death. So even though she was viewed as a daughter by this lady, we absolutely weren't going to take that risk. And then you've got, so you really have to make an assessment about the evidence. And so sometimes, again, we're making another statutory will application in a matter where we have had a settlement between adult siblings of a blood family. And long and the short of it is the settlement is on the basis that one of the children is getting their inheritance early, right? Effectively. And so the statutory will application is required, even though, because in Queensland we can't, and unlike New South Wales, we can't get a release for FPA, and you can't, before a person has died, renounce your entitlement to the estate. So, we have to do the statutory will application, and it will be by consent with everyone, that to adjust the will, because now he's received his share. So that's another reason. And sometimes, the other cases are the tax issues. So, there's been that one case where, they applied to have testamentary trusts inserted into the will so that, there was the tax planning would be there. So there's a number of reasons why, or, just circumstances change so that you need to make the new will, otherwise it's unworkable, or it's generally done that way in Queensland anyway. So yeah, I would be, if you were doing it to substitute for an FPA, I would be saying no, you can't and you shouldn't. But if there was actual evidence that there was an intention to make a will on different terms, or there was a need to adjust a will because of some kind of financial settlement, and that was how the Bundaberg case began. They're also in their family structuring, there had been a buyout of one of the family members in a family business, and so it required adjustment of the will for that reason. So yeah, I hope that I've answered that question as best I can.
No, definitely. And I know it was a bit like, it all depends on this and that. You've been very generous with your time. Last question, sorry. Has the judgment been published?
You know what? I don't know. We obviously had to get it all transcribed, both the actual hearing as well as the reasons. because we had to provide that to the charities who weren't represented, obviously, so that they could make their assessment on appeal, or for an appeal, which they thankfully didn't appeal. But so it was before Justice Bow School, and it was on the 30th and 31st of, what was the month? August, September, I think. It must have been August.
No, that was August.
August, yeah. So I don't know if it
We'll have a
has,
look.
yeah, I don't know if it has been published, but it definitely was transcribed. So yeah, that's my bad. I haven't looked it up because I've gone, whew, you know, I don't need to know that.
That's all right. I'll see if I can find it. Zinta, that was absolutely fantastic, and I'm so grateful for you sharing that whole experience
No worries.
with the whole group, because I mean, a really interesting case on its own, let alone having to open up the court on a Friday evening at midnight.
Well, and the referral actually came from a financial planner who, I think, if he's not a member of your group, was or knew of your group, and he was the one who picked this up with the client. Yes. So yes, I can't remember.
Was it Ray?
Ray. Yes, Ray. What's his surname?
Oh, yes. I told him to call you because I had no idea, and he called me. So I'm so glad
that was Ray.
You,
so that was Ray. So
like,
the financial planners played a key role here because, you know, they're the ones who are with the clients, yeah, and they're the ones who are talking to them on that more relational level. And as I said, this client had a very scary experience with her first lawyer. So yes, it was Ray.
Well, that's it. I mean, I think it's important for all the advisors in the group to know about the statutory will as a potential pathway, particularly because, as you sort of said, the applicant may not realise this is an option, and they may not know what to do, and you know, it would just be by incidentally mentioning it to another advisor that it comes up. So it is a really effective tool if you have a good case. So we need to know about it in the toolkit.
And it doesn't need to cost a lot either. I mean, I know this one probably did because of the urgency and the number of people involved, but had we been able to have the time, and had we been able to get the consent of all the charities to the, you know, proposed will, it would have been a much less costly application. So I know the cost is not great, but really it shouldn't be the one thing that stops people from doing it.
Well, thank you so much, Zinta. That was so insightful. You've been very generous with your time, so we'll let you get on your way.
Thank you.
And you've got your big trip over to the States, which I'm sure is keeping things busy for you. So thank you so much. And just for everybody, next week's topic, we're going to talk about the budget, or the announcements and the draft changes to the accepted trust income tax treatment for testamentary trusts. That's an interesting one because we haven't really seen any legislative reform to the accepted trust income rules for years and years. So that'll be a good one to just make sure you can stay on top of those proposed changes and the structuring impacts that will have for clients.
Awesome. Cool.
Well, safe travels, Zinta. Thank you so much.
No worries. Bye.